You just got hit with drug trafficking charges in Massachusetts. Mandatory minimums, prison time. Your entire life is on the line. But here's what they don't tell you. These cases have weaknesses, real ones. And I'm about to show you exactly where they break. I'm Matthew Peterson, a criminal defense attorney in Boston. Quick disclaimer, this is education, not legal advice about your case. You need your own lawyer. Now, let's break down how these defenses actually work. Drug trafficking charges are serious. We're talking years behind bars and a permanent record. But these cases can fall apart in two places, before trial and at trial. Let me show you both. Pretrial defenses, killing the case early. First is motions to suppress. This is a big one. This is where drug cases die. Picture this. Cop pulls you over for something minor. Says he smells weed. Starts searching your car without asking, without a warrant. Finds drugs. You're arrested. But here's the thing. That search might be illegal. And if it's illegal, that evidence disappears. The Fourth Amendment protects you from illegal searches. Police need three things to search you legally: a warrant, probable cause with emergency circumstances, or your actual consent. I smell marijuana isn't the automatic green light cops think it is anymore. Not after legalization in Massachusetts. Your attorney needs to examine everything. Body cam footage, dash cam, police reports, all of it. Looking for one question. Did police violate your rights? Because here's what happens when they did. That evidence gets suppressed, thrown out, gone. And without evidence, the prosecution has nothing. No case. It's over. I've seen cases with pounds of drugs get completely dismissed because the search was unconstitutional, before trial even starts. That's the power of a motion to suppress. Motion to dismiss. A motion to dismiss says, Judge, they can't even prove their case. Maybe they can't prove you possessed the drugs. Maybe they can't prove you knew what they were. Maybe their whole case depends on evidence that you just got thrown out. Even when a motion to dismiss doesn't win outright, it does something critical. It forces prosecutors to show their cards early. You see all their evidence, all their witnesses, every weak spot. Now you know exactly where to attack. Massachusetts law says prosecutors must prove three things. 1, that you possess drugs. 2, that you knew they were drugs. And 3, that you intended to sell them. If they miss any one of these, the charge falls apart. This motion creates pressure. It exposes problems. And it gives you leverage when it's time to negotiate. Now let's move on to trial defenses. Destroying their case in court. Personal use defense. Stop. See, this is huge. Most people don't understand this. In Massachusetts, personal use is a complete defense to drug trafficking charges. Read that again. Personal use defeats trafficking. The prosecution has to prove you intended to distribute or sell the drugs. Just having them isn't enough, even if you have more than the weight. They have to prove you were dealing. Well, how do they prove that? They look for indicators that you are a dealer. They look for dealer evidence, scales and baggies, lots of cash, multiple phones, text messages about sales, drugs divided up into small amounts, customer lists. But what if you don't have any of that? What if it's just drugs in one container? No scales, no baggies, no dealing text, nothing. That's personal use. And that changes everything. The burden is on them to prove you were selling beyond a reasonable doubt. And if all they've got is weight with no context, you've got a defense. I've defended people with significant quantities of drugs where prosecutors couldn't prove that they intended to sell them. Just drugs for personal use. That converts a trafficking charge with mandatory prison time into a possession charge with possible probation. This defense is powerful, and most people facing drug trafficking charges don't even know it exists. Constructive possession. See, here's where cases get complicated. Just because drugs were near you doesn't mean you possess them. Massachusetts law requires 2 things for possession. 1, that you knew the drugs were there, and 2, that you could control them and that you intended to. Think about these situations. Drugs found in an apartment with 3 roommates. Drugs in a car with 4 people inside. Drugs in a package delivered to your house that you never opened. Who actually possessed those drugs? Can prosecutors prove that you knew about them? Can they prove that you controlled them? That's the question your attorney hammers at trial. See, here's a real example. 4 people are in a car. Drugs were under the back seat. Everyone gets arrested for trafficking. but who actually possessed them? Can they prove that all 4 people knew about them? Can they prove that you specifically controlled them? If there's reasonable doubt about knowledge or control, that's not possession. And without possession, there's no trafficking conviction. I've defended cases where drugs were in my client, but hidden in a roommate's area. My client never accessed them, didn't know the drugs existed. How is that possession? It's not. See, knowledge plus control equals possession. Fail either one, and the charge doesn't stick. Lab errors. See, crime labs make mistakes. Let's talk about that. Samples get contaminated. Weights get recorded wrong. Chain of custody breaks. Field tests give false results. Remember the Massachusetts crime lab scandals? Annie Dukin tampered with evidence in over 24,000 cases. Sonia Farak was literally using the drugs she was supposed to be testing. Thousands of convictions got overturned. These weren't rare mistakes. They exposed serious problems in how drug evidence gets handled. Your attorney should attack the lab evidence hard. Are the lab techs properly trained and certified? Is the chain of custody clean? Can they prove that this exact sample they tested stayed secure from seizure to testing? Were the scales calibrated correctly? Did field tests give false positives? See, field tests are notoriously unreliable. They flag innocent substances as drugs all the time. The lab has to confirm what the field test claimed. And here's something critical. If the weight is off by even a few grams, that might drop you from trafficking to possession. Those grams determine whether you're facing mandatory years in prison or potential probation. Challenge the science, always. Effective defense means fighting on all fronts. Before trial, you file motions to suppress and dismiss. You attack illegal searches. You challenge weak evidence. You expose holes in their case. Best outcome, the case gets dismissed before trial. But the minimum outcome is you create a massive leverage. If you go to trial, hit them with personal use defenses, constructive possession challenges, and lab analysis attacks. You create reasonable doubt on every single element they have to prove. Here's the reality. Most cases, they don't go to trial. They settle through plea deals. Our prosecutors only offer good deals to defendants who show they're ready to fight and ready to win. When prosecutors see their case has problems, illegal searches, shaky possession proof, no dealing evidence, questionable lab work, that's when they negotiate. That's when trafficking can drop to possession. When mandatory minimum prison time confers to probation. When years behind bars becomes treatment programs instead. Massachusetts has drug court programs and alternative sentencing options, but you only get access through leverage. And leverage comes from fighting hard. Drug trafficking charges in Massachusetts carry devastating consequences, but they're not automatic convictions. These cases have constitutional problems, evidentiary gaps, and legitimate defenses. The prosecution has to prove every element beyond a reasonable doubt. You don't have to prove innocence. They have to prove guilt. And skilled defense attorneys exploit every weakness in their case. If you're facing these charges, get an attorney who knows how to fight both pre-trial and at trial. Someone who challenges unconstitutional searches, attacks weak evidence, and forces the Commonwealth to prove its case. Your future depends on your defense. Make it count. Find out more in our blog below.